Good morning, everyone, and welcome to the Clackamas County Board of Commissioners Policy Session, August 7, 2024. We're going to make an adjustment in the schedule today, Commissioners, based on new information coming in, realizing we don't need as much time to do these sessions. We don't need an hour for every session. So I've had a request from one commissioner of new breaking information regarding the decision on the deflection funding coming from the state of Oregon. There was a second decision that was had this morning. And Gary, do you want to brief the commissioners on that?
Yes, so as far as the scheduling, here's what we will do, is we'll start with an update on the deflection plan from the committee meeting that happened with the state this morning. And I think Commissioner West is fully briefed and can brief you all what happened. And then for the policy sessions, I recommend this order this morning. The Psilocybin discussion first, because you must make a decision in the next 2 weeks, and that is timely. Second, the recreational vehicle as second dwellings session. Third, the the Enhanced Law Enforcement District, IGA, move that up to the morning, and then board rules. But we can certainly postpone ELED if you're running out of time, because we need to get to board rules this morning. So that is my proposal for your schedule.
Okay, Commissioners, there's been a moving target this morning. We're going to start with the Deflection Center update because we have a meeting, we have a luncheon at noon that I must be at. I'm hoping the rest of the commissioners will too. I'd like to go ahead and discuss that.
Yes.
If we could.
Yes.
We were initially considered again, but then rejected because of a parliamentary move on that. But who wants to talk about it? Ben, you want to go ahead and talk about it?
Thank you, Chair. I got a call from Rep. Anessa Hartman, who district is here in Clackamas County, and her district also is in the portion of Clackamas County that's in the metro area. And Chair, you are correct. There was a parliamentary kind of maneuver where the motion to reconsider needed to be made by someone who was not supportive of the someone who had voted no previously or voted to deny us our application. The person who made the motion was a DA out of Deschutes County. He was supportive of our application, is my understanding. Anyways, so they also said, hey, wait a second. Some other members are not here. They are members that are quite in opposition of ours that were not there this morning. So they went ahead and heard all the other counties. Washington was one of them. They approved Washington's counties with notes and consideration back, and allow them to have some flexibility to say, hey, we know this is a pilot. Here's some notes. Here's our thoughts on it. Your application is approved. What's interesting is Washington County's application is very similar to our application. Very, very slight differences, but it's really kind of the same mindset on how to address this deflection program. They gave notes also to Yamhill County. I think they also heard Umatilla. I can't remember exactly, but they're trying to get through the applications. My concern is they are continuing to kick the can a little bit before they take up our application. We do have real time constraints. We are definitely now in threat of having this new House Bill 4002 become statute and law and active, while we don't have a deflection program up at all alongside of it. So that whole piece of deflection with this new law, we won't have in time. We don't have the time to do the hiring, the contract work necessary. It was already razor thin in the longer that they pushed this out by September 1st. Mary Rombos told me I do not have the ability to get this up right away. So it puts us kind of in a precarious situation, at least for the next few weeks as the statute is enacted. Hopefully, Chair, you told me the governor is.
I spoke with the governor.
You spoke to the governor?
I can speak to that.
And so that's the update today. And we're not quite sure when they're going to pick up our application, but the understanding is when they're done hearing everyone else's, it just eats at our time, which is unfortunate.
Gary, in the end of Trent's email, there was a Lane County participant who said what?
So it is Judge Suzanne Shanty from Eugene, Lane County. She's the one who made the motion for the reconsideration of Clackamas County's application, which was approved, but they ran out of time today's meeting, so they're going to reschedule another meeting to be determined. But she made the motion.
And they're doing a doodle poll to consider when to come back. My conversations with John Wentworth last night said he's willing to make some concessions to get this approved. However, I don't think they listened to him today, did they?
You didn't not have a chance to speak.
Yeah, he has not had a chance to speak. I've been playing phone tag with the governor, and I called her yesterday and this morning. She called back, and I was in another meeting this morning, but she did leave a message. She is not aware of the second decision of denial when she left my message, but she did say that she's instructed the committee members to be fair and treat all counties the same, basically is what she said. So I look forward to speaking with her again this afternoon, once things shell out a little bit. We do have a good letter here from our Clackamas County caucus. And to me, what's very telling in this letter, and they all signed it, and they're very supportive of what they're doing. One of the middle paragraph states, the state legislature passed House Bill 4002 with broad definitions to encourage local agencies to design deflection programs that match the needs of local communities. And we have done exactly that. And I do think this committee, the specially appointed committee, is also outside the purview of House Bill 4002. How they got that, it's against the law. It's basically against the law that this committee even exists. So there's a formula coming out, and what I'm concerned about, Commissioners, let's say that we are successful in this round. In this long session in 2025, they're going to reconsider the funding formula again. And we may not be on the appreciative end of that funding formula. In 25, once we already have a program stood up, will they subtract our funding for that? And so there's a lot of considerations here that are not good. Commissioner Savas?
Yeah, I turned my light on before this topic, so my issue was point of order. Several commissioners wanted to have the board rules on the agenda,
It is.
and now it's being moved.
It's on the agenda.
It's on the agenda, but it has been over 2 years. This discussion has been going on for 3 years, and every time there is it's being subverted.
Morning.
It feels as though it's being subverted. So
Jamie, comment?
typically, in my understanding of board of rules, if there's an agenda change, number one, it's not being very transparent and open to the public, and when you change the agenda at the last minute, without good cause, I don't mind having the deflection discussion. That's fine, right? But to just completely rearrange the schedule, and then people are either going to watch, because it's notice a weekend event. What's the purpose of noticing the meetings at a certain time if you're just going to subvert that? So my understanding is, Robert's Rules of Order, if there's an agenda change, the board votes on it.
Jane?
But of course, that's board rules, and we don't follow board rules. We don't follow Robert's Rules of Order. It just seems to be whatever it is of the pleasure of the chair.
I would
I
highly
object to the
disagree.
change. I object to the discussion of having the change, and not allowing us to even discuss it.
That is not true, Commissioner Savas. Board rules is up today. I just moved it because I did not know how long this discussion would take. We have 2 hours for 2 topics this morning. It's very obvious. I don't think it's going to take an entire 2 hours to discuss 2 topics. I talked about with Gary, I talked about with County Council, if it was in the purview to do this. Would you like to make a comment?
So I think that the schedule change isn't that the item is being removed, but it's being shifted, I believe, an hour off. And I do think that is the purpose of an agenda under the Public Meetings Act is to give notice of a topic. But I think that the time flexibility within the time allocated for these policy sessions, I think it is appropriate to move it if needed.
I move that we keep the board rules topic next on the agenda after the deflection discussion.
Was it already?
It is.
It's up at 1:30, or it's up at 11:30.
11:30? That's a half an hour.
It's up at 11:30.
I'm confused. even though we're just talking about deflection right now, and then we're going directly into
Gary,
board
what's this-
rules? Is
Gary,
that what we're
was the
doing? So I just
proposed-
don't understand.
No, I don't understand either, because it's not being clearly presented.
I know we're moving stuff around based on like not needing as much time and it's a packed day. Could you review that again, please, Gary?
Absolutely. What I'm proposing is that after this deflection update, you have your psilocybin policy session, your RV policy session. I suggested ELED, but forget it. Go right to board rules. So it's just reordering what was already noticed for this morning. But you decide what order you want to go.
So you wanted to go mushrooms, RV, what was next?
I was suggesting ELED, then board rules, but let's just take out ELED, so board rules. So psilocybin, RVs, board rules.
Why do we need to, why would, what board rules was first thing this morning? We're gonna get to all of it. What's the point of moving it down to this afternoon?
Psilocybin is most urgent because you're coming up with a deadline to file the ballot language. So that has to be done today. Has to be.
But we have until 3:30 today. We have hours. I don't understand.
Unless we don't discuss everything. Go ahead, Jane.
So part of this may be from my perspective. Caleb Hugel drafted the psilocybin. He does have a summary judgment motion this afternoon. So it is better for my office if he'd be able to present this morning. I apologize for the inconvenience.
Okay, so let's do I request at the very minimum that we do, let's do the psilocybin, and then following that, board rules.
I'm fine with that. We're all gonna get to it all.
That's fine with me.
Are we okay with that? Sure.
Sure, go ahead.
Okay.
Jane, your light is still on. Yeah, that's okay, that's fine. Okay, any more discussion on any information regarding the deflection program?
Has anybody called the President of the Senate and the Speaker of the House? I know both of them.
Rayfield's been in conversation with,
Okay.
and involved in this. I do know, I don't think we've directly spoken with Rayfield. We haven't heard much from
Well, it's
Senator
Julie-
Wagner.
I think it's Julie Fahey now, isn't it? I think,
It might be, yeah,
yeah.
I think maybe until the session starts. I don't know technically.
Okay.
It might be Fahey, but I
Yeah.
heard it with Rayfield was engaged
Still,
in
okay.
conversation around it. And we thought this morning we would be able to make the motion to reconsider. It would be reconsidered and would be decided today. Originally, we thought the person who would make that motion was going to be the Deschutes. It turns out it was the judge out of Lynn, but they basically punted on hearing our application again today, even though the motion
Okay,
was
yeah,
made.
that I get. So it's not over till it's over.
It's not over, it's just eating up time we don't have.
Right.
Yeah.
Okay, thank you.
And implementing the program could be delayed.
Right.
For, I don't know how long.
And Lipstick has spent a lot of time and effort on this, a lot of consideration with multiple authorities. So it's just a little, it's just a little curious why it's happening this way, but.
Okay, Gary, what's up next?
Okay, your first policy session today is psilocybin ballot title and explanatory statement. The county council team will present. Jane Veto, county council, Caleb Hugel, assistant county council.
Welcome, go ahead.
Good morning, Commissioners. As you know, Measure 109, passed by the voters in 2020, legalizes but requires the Oregon Health Authority to license and regulate psilocybin service centers and psilocybin product manufacturers. Measure 109 authorizes counties to ban those uses in unincorporated areas, but those bans are subject to approval by the voters. In June, you adopted an ordinance permanently banning those uses. Now we need to file the paperwork necessary to get that ordinance on the November ballot. We need to file that paperwork by August 16th. Specifically, we need to file a proposed ballot title, which consists of 3 parts. A caption not exceeding 10 words, which is descriptive. A question not exceeding 20 words, which explains the purpose of the ballot measure. And a summary not exceeding 175 words, which describes the major effects of the ballot measure. We've prepared draft materials for your review. I should say that these materials are based on the materials that were filed in 2022 when the board adopted and voters approved a temporary ban on these uses. Just to lay out sort of the broader process, if you approve these materials and we file them, the elections official will publish notice of them and they can be challenged in circuit court if they're too vague, if they're too long, if they're biased. However, if nobody challenges them within 7 days of when we file them, then we refile the ballot title, not as a proposed ballot title, but as a final ballot title, as well as an explanatory statement, which can't exceed 500 words. And that goes in the voter's pamphlet. It's sort of an unbiased explanation of what this ballot measure is about. And we've included a draft explanatory statement for your review as well, so that we don't have to come back to you later if nobody challenges the proposed ballot title. And I'm happy to answer any questions.
Commissioner West.
I'm looking at the summary, 140 words, the second sentence, and psilocybin service centers are defined as establishments where a client purchases, consumes, and experiences the effects of psilocybin under the supervision of the psilocybin service facilitator. Can we be more bold than effects? I mean, Benadryl gives me an effect, psilocybin gives me psychotropic, psychotropic mind-altering substance.
We could add some more specifics. This language comes from state law. It's pulled almost verbatim out of statute.
So I'm curious then, do we get to tweak kind of the summary, or do we have to use what's in state law? I kind of want to make it clear that it's a psychotropic mind-altering substance.
So what goes on the ballot has to be very, very neutral. I think what you are thinking about might be covered in the explanatory statement.
Okay.
Where we kind of explain that it is a naturally occurring hallucinogenic.
Okay.
So we go into more detail.
Okay.
So
Do you
that's
think
where that
a
is.
mind-altering psychotropic, that sounds like we use that in medicine, is that not, in your legal opinion, is that not neutral enough to have that language in there?
I think if we do include that, it should be in the explanatory statement, not in the summary.
Okay. So I just want to make it clear that people understand the potential effects if they consume this, that they could experience clearly. And I think that understanding that it is a psychotropic that's mind-altering and hallucinogenic is important.
And just to clarify the correction, it's psilocybin is a naturally occurring hallucinogenic, mind-altering psychotropic chemical.
Yeah, that would work.
Okay.
Isn't that what it says?
They added the
They
money
added that.
language. Yeah, if the board's okay with considering that.
I'm okay. Commissioners, you okay with that? Commissioner Savas?
Yeah, as long as we include the word hallucinogenic, I think that is, just so that vocabulary is comprehensive to the average citizen. So that word, as long as we retain that word, my concern was just substituting your words for hallucinogenic, because I'm not sure a lot of people will even know what that is.
Okay, fair enough.
We can do that.
We will have both.
Okay. Do we need a motion on this? Recommendation. Staff recommends, I'll entertain a motion.
I move to direct staff to file the draft ballot title and explanatory statement with the elections official.
Seconded.
Commissioner Savas has moved we direct staff to draft a ballot title regarding psilocybin mushrooms on the ballot title with the elections officials, and Commissioner Scholl has seconded the motion.
One small amendment, just to recognize the amendment made by Commissioner West.
Okay? And we're all in agreement with the amendment, correct?
Yep.
All right, it has been moved and seconded. Tony, please take the poll.
Commissioner Schrader.
Aye.
Commissioner West.
Aye.
Commissioner Scholl.
Aye.
Commissioner Savas.
Aye.
Chair Smith.
Aye, motion passes 5-0. Ben?
I know that these can be, a quick question on this process-wise, and maybe this is a question for the county clerk. What's the cost? And this is coming into the general election, correct? We're going to see this in November ballots. I'm just curious, that's a big presidential election. I'm just curious what the cost is to the county to push this question forward.
I'm not aware of any cost at this time.
Maybe some of that practical stuff from the county clerk would be interesting to know.
I recall the last time you discussed an item, it's approximately $20,000 to $25,000.
Okay.
So there's a cost, but obviously we'll cover that.
Cool. I'm just curious about the ballot part of it, process-wise. Thank you.
Thank you very much. Gary, what's next?
All right, next, board rules. County Counsel Jane Vetto will kick this off.
All right, sorry.
Oh,
Back in front of the dais. Great. Thank you, Commissioners, for your patience while I got my papers together. For the record, I am Jane Vetto, County Counsel. And this morning, we are here to continue a discussion that predates me, and I also believe Commissioner West, on some proposed board rules. Just to kind of get you up to speed, I think this was brought to the board a few years ago, and there were several meetings, and the result of those meetings was 2 separate documents of board processes and procedures and protocols, which this board currently does not have. There was a document that I believe the majority of the board was amenable to adopting, but there was consensus that this should be a unanimous group decision, and at least one other, and I'm not sure how many commissioners opted for a second version, which is called Exhibit 2, or the minority report in your packet. So I have Exhibit 1, which is what the majority of the board was considering adopting 2 years ago, and then Exhibit 2. And so for today, what I'm wondering is, would it be helpful if I went through these 2 documents and I kind of gave an overview of where the differences are in the 2 documents, and then open it up for discussion?
Yes, go ahead.
All right. So the first section is organization. And if you go down to subsection D on both documents, Exhibit 1 and Exhibit 2, the difference is, on Exhibit 1, again, what the majority was looking at, there's a sentence that says, "All questions and remarks will be directed to the chair. The chair will recognize commissioners, staff, and members of the public that desire to speak." The corresponding section D on Exhibit 2 says, "Commissioners, staff, and members of the public that desire to speak will be recognized." Okay, so it eliminates the role of the chair from inviting people to speak. Subsection E, same section, Section 1, subsection E. The majority report, Exhibit 1, the chair will designate a time limit for any public comment or communication. Subsection E on Exhibit 2, the chair may designate a time limit for comment, communication, or deliberation, subject to an appeal from the board. So that's the difference there. I'm not sure that's super clear, but I will lead out my editorializing. Okay, Section 2, so that's the only changes that I see. Oh, no. On subsection F, under the Exhibit 1, it says the chair will sign all documents approved at the board meeting or with the consent of the board, delegating signing authority to the county administrator. Exhibit 2 says, again, the chair will sign all documents approved at the board meeting or with the consent of the board, delegate signing authority to the vice chair, the county administrator, or other designated county official. So that's the changes, and those are pretty significant changes for Section 1. Section 2 and Section 3 of both documents are identical. So then moving to Section 4 of both documents. Under Section 4A, the first change is at 4A subsection 5. In the majority, Exhibit 1, the majority document, when it is in the public interest, the chair by majority vote of any meeting may adjourn to another time or location accessible to the public. That same section over in Exhibit 2 reads, the chair may order a recess of any meeting at any time for any reason. When it is in the public's interest, the board, by majority of any meeting, may adjourn to another time or location accessible to the public. So that adds a new sentence and changes chair in the second sentence to board. Subsection B, 4B, is the same, and subsection C, executive sessions, is the same. Moving on to Section 5, notice and agenda. The first change comes in under D. Under the Exhibit 1, the majority document, the chair sets the board meeting agendas. 2 other commissioners may place matters on issues for discussion. That same paragraph on Exhibit 2 reads, the chair will establish the agenda for each meeting of the Board of County Commissioners. 2 or more commissioners may call a meeting or place any item on the agenda of a meeting of the Board of County Commissioners either directly or over the objection of the chair. So a significant difference there between those 2. Section 5F, there's only one change in section F. If you look at the second sentence, it says the Exhibit 1 reads, "At the request of any commissioner," and Exhibit 2 says, "At the request of any single commissioner." I'm not sure there's a real difference there. That's just a semantic. And then G, under Section 5, agenda items, Exhibit 1, agenda items may be taken out of order at the discretion of the chair or at the recommendation of the county administrator. Exhibit 2 reads, agenda items may be taken out of order at the discretion of the chair, any two commissioners, so that's the change there, or at the recommendation of the county administrator. Okay, Section 6, there is a change, paragraph B. Under Exhibit 1, commissioners will provide verbal, written, or electronic mail notification of all anticipated absences from board meetings to the chair, each other, or the county administrator. This requirement does not exist in Exhibit 2. So there is no notification requirement of anticipated absences in Exhibit 2. Section 7 are identical between the two. Section 8, public testimony are the same. Section 9, ordinances are the same. Section 10, application of the rules, are the same between the two documents. The next change under Section 11 is board messaging. Under Exhibit 1, what's called the majority report, there is a sentence that says, any commissioner may express their position or basis for opposing a position taken by a quorum of the commission, but should not actively attempt to undermine a decision of the board. That sentence is not included in Exhibit 2. So there is no,
What was that again, Jane?
Pardon?
What was that again?
It was, any commissioner may express their position or basis for opposing a position taken by a quorum of the commission, but should not actively attempt to undermine a decision of the board. And again, that sentence does not exist in the Exhibit 2, what we're calling the minority report here.
Can you cite what section and what number that was?
Yeah, that is Section 11A.
11A. Okay, yeah, okay. I put a note on that. All right.
Okay. And then, jumping down to 11D, it's a one sentence, but the change there is under Exhibit 1, it reads, any board member may write a letter or express an opinion as an individual, and D is any commissioner member. Again, I don't think that there's a real difference there. The big change here now is going to Exhibit 2. There is a new Section 12 called Board Actions and Complaints. That section does not exist in Exhibit 1. So Section 12 of Exhibit 2 Minority Report has two sections. Section 12A, the board is self-governing and may not take adverse action against any commissioner. Such action may include, but not be limited to, a public reprimand, an admonishment, a censure, removal, or reassignment of liaison duties, and other actions as deemed warranted by the board. If any adverse action is formally undertaken by the board concerning any commissioner, that matter shall be revisited by the board for reevaluation or reconsideration after 180 days. Again, that section does not exist in Exhibit 1. Likewise, new Section 12B in Exhibit 2 reads, if a workplace-related complaint is filed against any commissioner, the matter will be referred to County Human Resources, where it will be investigated and handled in a manner comparable to the process set forth in County Employment Policy and Procedure Number 2. There is no corresponding provision in Exhibit 1.
I'm sorry, I just lost track. Where is that again? The one you just described?
That is, if there's a harassment complaint filed against a commissioner, this provides that it will be investigated pursuant to county policy.
It's B.
Yes.
12B.
Isn't that already in county policy?
I believe so.
We have a separate committee set aside for that. I don't know why we need to state that in board rules. But that's just, go ahead, Jane.
Well, so just going through, so then the sections are renumbered in the two documents going forward because there's a new Section 12. So Section 12 and Section 13 of these two documents are identical, and that's miscellaneous. And then Section 13 in Exhibit 1, adoption, and Section 14, adoption and Exhibit 2 are identical. So that was a quick overview of the changes. You can see some are very minor, some are very substantial. I open it up to discussion for you, unless you have questions for me.
Thank you. I've done a lot of contemplating about this, and I'm a little bit struck by some accusations that have been circling around. I'm supportive of the Exhibit 1 document. I think that allows for the best flexibility. It gives us some guidelines. It also adheres to what the citizens passed when they created a 5-commission members, giving the chair the authority to set the agenda and run the meetings. I have always tried, to the absolute best of my human ability, to give every commissioner an opportunity to bring issues forward, to give every commissioner opportunity to voice their opinions. We have discussed board rules about every single year. And I do think it's disingenuous on the person promoting this to say somehow there's something wrong with the current system, and I do feel that I've been singled out as chair. But unless you're going to change the entire process of Clackamas County, the chair does have the right to run them, and I don't see how, Jane, we can alter from that unless we go to the voters and ask them. The chair does not have the ability to run the meetings or set the agenda. Commissioner Savas.
Yeah. Thank you, Jane, for your opening of this. My suggestion maybe is we almost duplicate what you just did, except opine on which one we want. And I don't know which document we want to guide from, which is more, should we work on document 2 as the main one? Or, procedurally, whatever you think there. But I have another comment. But go ahead and share how I want to go through those, because you hit on each one of the ones I already highlighted that I wanted to talk about. So you hit on the key issues.
My recommendation would be, since there has already been some consensus around Exhibit 1, that be the document that there be any comment on or changes to today. So if you're going to discuss, I would discuss from Exhibit 1.
Okay. Okay. And one clarification, just from being the history of this, is that we have gone back and forth with this, and one commissioner makes edits, and then another commissioner makes edits to the edits, and it just compounds the confusion. So we've been all over the map. And as I mentioned earlier, this has been something that we felt the call for 3 years to have this discussion. So let's just start. I'll take your advice. Let's start with Exhibit 1. And the first one, under Section 1, you didn't really talk about, but it's kind of related to D. So Section 1C and Section 1D, and you mentioned D. So what exactly does 1C mean? Questions of order.
And you're right, I did speak about that because I do think that is a very broad ending, subject to an appeal to the board. Reading that, I don't actually know what that means.
Yeah.
But I think the first part is pretty clear, and it is the precedent that we are following right now, which is that the chair runs the meeting. She sets the questions up for order. She addresses any parliamentary questions that come up. That is how I interpret that.
C?
Yes.
Okay, so how would you make that more clear?
I would delete subject to an appeal to the board just because I don't know what that means.
What one are we on, Jane?
We are on Exhibit 1. The chair sets all questions of order subject to an appeal to the board. Commissioner Savas asked me how I would make this more clear. I would get rid of subject to an appeal to the board just because I don't know what that means.
Okay, and what does question mean?
sets all questions of order. To me, that's just again, I didn't draft this language, but as I read it, this means that you, as the chair or the chair, sets the, calls the questions, answers the questions of orders, deliberates, sets the motions, runs the meeting, essentially, is how I read that.
Okay. I appreciate that. I was after the definition. I wasn't contesting the language, just
Okay.
trying to understand. So what would make it more clear to the general public?
Again, I think,
I mean, without changing anything, how would it be more clear?
well, I think the audience here is the board. And so the question is, when a board member comes in and they want to know how a meeting's run and how it's done, they should be able to read this document. And so if they read, the chair sets all the questions of order, and they're familiar with parliamentary practice, I think that that is pretty clear. And then that kind of goes into the rest of this document. I think when you open it up to subject to an appeal to the board, I'm not clear what that means. Does that mean a public appeal? Does that mean appeal among you? I don't know what that means. So I would either change that language or modify it.
Okay, so the reason I bring that up, because I wondered if it was, we have, the public can't see it, but we have this lighting system, right? So when we want to be recognized, which may be a question, could be a comment, but when we put our card up, or our light on, we get recognized in order of the lights going up. But that doesn't always happen. I mean, yesterday was a great example. I won't go into detail because I don't want to make anyone mad, but yesterday, including this morning, my light can be on for a significant period of time, and then other lights come on, and I'll be the last to be recognized. So in a lot of meetings, Jane, a lot of people do this. A commissioner or a city councilor will put their placard up to be recognized. The public can see that the placard is up, that they can be recognized, and then the chair or the mayor or whoever it may be will recognize that person in order. But the public can't see the light show in the background. So I interpreted that section 1C, that the chair sets the order. And I don't mind any of that language in there, but I was just unclear really what that meant. It makes sense. I'm not here to question how that is, but that is one little challenge that I've had. I'm not the only one who's had that challenge, but I just wondered, maybe the chair maintains order of the meeting, subject to appeal of the board.
Commissioners, listen, I understand Commissioner Savas always wants to speak first, and he wants to dominate most conversations. And that's what he has, basically, he challenges me on that. However, I've chosen to be a very judicious chair and fair, and allowing other commissioners their ample opportunity to take a first view or a second view or a third view. And I feel that that's the fairest way to run a meeting. And so that's what I'm going to continue to do. I think just because somebody raises their hand first and is most energetic, I think all conversations need to be considered equally, and I try to spread out the time equally for every commissioner to opine on whether it's an executive session, open sessions. So I think we're getting down to an area that, gee, I can't pick a light on my light board. I think it's important because I feel if one commissioner, and I'm not saying who, is so overbearing in their opinion, that doesn't give ample opportunity for the other commissioners to be heard. Additionally, I will say on most of the policy sessions we have, I'm the last to speak, except for points of clarification after a presentation has been made. I usually allow for most of the other commissioners to speak on this. And I allow as much time as needed, but really the order of the way the lights go on. First of all, I don't know always the order of the lights that go on, and I will ask, well, who's up next? Okay, I try to be as fair as possible on that going forward.
So, thank you. I do notice that there was consensus last time the board met around this language, and I think because of your agenda today, it may be helpful if the board identifies the areas they really have a significant disagreement with, and we go into that. And I don't know if it could be led maybe by Commissioner West, who hasn't already seen these before. Is there anything in here that, on Exhibit 1 that you would like to see edited or beefed up that I can work with you on? And I can help kind of lead you to the ones that I think there is significant difference.
Do you want me to start on C here?
Or C, not C, because I think there was consensus there. But like D and E, there was a little bit of difference there, not many. I think the question about whether there has to be advance notice is important. I think the question of recessing is probably something that may come up. And I do think the new Section 12, or if we're going on Exhibit 1, the potential addition of board actions and complaints may be something you want to talk about.
Let me ask you this question, just for the public's knowledge, because we have two, Exhibit 1, Exhibit 2. Exhibit 2 is the minority report. Just for clarification process, where did the minority report come from if Exhibit 1 is what's currently in place?
There is nothing in place. There was no vote on
We have
any
nothing.
of these. Yeah,
So
that is my
these are two
understanding.
competing thoughts and opinions about, and then where did these two exhibits come from?
My understanding is that there was a prior series of sessions about 2 years ago. Out of those sessions, there was consensus by a majority on Exhibit 1. I do not
Never
know
adopted, though.
who authored Exhibit 2 or who made those changes. I do not know.
Okay, so we're just going off the two things we kind of already have in place. Does anybody know the history? I'm just curious.
Gary?
Do we know?
The minority report was drafted by Commissioners Savas and Shull.
Okay, and Exhibit 1 was drafted by a previous board from 3 years ago?
It would have been Chair Smith, Commissioner Schrader, and I'm guessing Commissioner Fisher
And county council.
and County Council. Okay.
So can I have some clarification?
So, Paul, this is a conundrum for me. You put your light on after Martha's. So, now, if I go to the first light that was on, that would be Martha's, but you want to inject yourself ahead of that.
I'm fine waiting,
Correct.
guys.
Whatever standard you want to use today, I suppose. Chair, you're the chair.
Well,
But-
the
but
thing
this-
is, but
It's
you-
almost like a triple standard. It seems a very
It's
per
not
day. I
because-
appreciate your admission earlier that you do take discretion in which lights get recognized as opposed to the order in which they're lit.
But I'm trying
Okay.
to do what you want to do, and that would be Martha's light. But you
When
know what?
Commissioner West looked at me and asked me the question, it seems,
answer.
it seems as though it was.
I'm just pointing out the absurdity of the light board. But Paul, go ahead and answer.
Go ahead, Martha.
Okay, so all I wanted to say was, I've got the two sheets in front of me.
Would you speak in?
Oh, I have the two sheets in front of me, and I marked the first Exhibit 1, and I'm looking at the changes. And I'm trying to, and I like going through it this way so I can assess it. And I guess my question is, like for 1E, and this is helpful to me to look at it this way, okay, on either sides, because then I can see where the changes are, so I can ask, well, why the change? So in 1E, when we say, subject to an appeal to the board, I'm not sure what that means.
I
Does it-
also do not know what that
Yeah.
means.
I read that, so this is for public, okay, so for E, it's for public comment.
Yeah.
So I read that to say, someone's reading off their iPhone and they have a prepared statement, and then the buzzer reads, they may say, can I continue?
Okay,
That's how I read that.
okay, to an appeal of the board,
Yeah.
okay.
Okay.
And I usually said yes, except if we're so time crunched, we can't get out of the
Right.
building.
So it doesn't mean that you have to, but you can consider that as a possibility action, right? That's what I'm asking. So in other words, 2D, when we are time crunched, it is a, you can say, okay, we have to limit this, but we can't, but generally, but generally, the appeal to the board, in other words, that would include more of us saying, well, we'd like to kind of have to finish hearing this. Is that what I'm?
Well,
I mean, that's why I'm trying to get the nuances of why we're making changes, if we make changes. That's,
I think that this goes to the chair runs the meeting, so the chair, he or she decides, do we have enough time? Do we have 20 people waiting behind, or do we only have one person giving testimony today, and they can have more time? But as running the meeting, that is within their purview under Exhibit 1.
Right, so that's not going to change that, then.
Okay.
That's all I wanted to check. It's not going to
Well,
change
it could
that.
be changed. I could say, I'm going to limit the testimony today, say there's a packed room, not to 3 minutes, but 2 minutes. The commissioner could appeal that and say, no, I want to listen to everything, but that may not be the most legal, prudent, or judicious way to run a meeting.
Yes.
See, that's the problem.
That's the problem. I mean, we could have meetings that go on here for 10 hours. I mean, if we don't have some limits.
Then why would you want to adopt subject to an appeal to the board if that's the case?
Yeah, that's,
Okay.
I don't know. That's one of the reasons why I'm pointing it out. What does it mean and what will it do to our process?
Commissioner Savas, you're up, and then Commissioner Scholl.
So in response to, I believe, the question that Commissioner West was asking, and also a clarification, so I'll try to do both at the same comment here, and that is that the board did not actually discuss this in a way transparently in public. So what you see as option 1, or Exhibit 1, was a little bit of conversation and a whole bunch of stuff behind the scenes. It was kind of being managed by Council Madcore. And not all commissioners participated in that. So technically, I would say that there's not really a minority report or a majority report, because it was never discussed in that way, right? It was never done in a process that one would determine Commissioner Schrader participated at. Only a couple commissioners participated in the edits. So to Commissioner West, I'm kind of looking at this as 2 different drafts that have both been tweaked by a couple commissioners, but never a majority of the commissioners, and never on the table. So none of them have ever been adopted. None of them are in place, as Council Veto has identified. So I would appreciate maybe we just pick one and then go down each item and say, are we okay with that? And just knock them out in what you identified as the distinction of the 2, Council Veto, if we could.
We have 2 other commissioners in the queue. Commissioner Scholl.
Okay, so I like the changes in Exhibit 2. The wording, again, I know we're beating this up pretty bad, but on Section 1, subparagraph C, that wording, did we just decide to drop the words subject to an appeal to the board?
I don't think so. I think that was a suggestion that I made, but when I look at this, you guys, however it happened, the board already reached consensus, and I think that today you should really focus on the areas where you had differences in the past.
Okay. And the other comment is, well, on Section 5, we're going to get there later, right?
I think going
I'll
sequentially.
hold my comment on Section 5 until we get there.
Section
Thank-
5.
That's all I have.
Yeah, so if,
Commissioner Paul, Commissioner West has his light on.
okay.
Go ahead.
I know that we're specifically talking about looping back C, D, and E under Section 1. I know there's some changes in F also. I have no bias towards this, like, language whatsoever. I am new. This is not so I maybe bring a fresh pair of eyes. I have no problem with C the way that it's written. I think of D in this sense as I remember when we had a packed house. I was probably, I don't know what issue it was, but it was packed and we had signs on one side and signs on the other side, and everybody wanted to have a conversation. The chair, I believe, made the correct decision, even though it may not have been popular, to say, hey, we got to limit. I'm just using this as an example that I think addresses what we were talking about, Ms. Veto, is she had to pick a time frame to limit her. We would have been here till 6 a.m. Not everybody liked that it was 60 seconds or 90 seconds or 2 minutes, but she had to make a call. She did. Many people did try to lobby us to say, hey, why was it so short? I remember we all had those phone calls. and we ask people not to double up their testimony. I guess the way it's written in Minority Report 2, the majority of the board, I don't know if this actually changes, I don't know if we could have already done this, could say, hey, you have 3 commissioners, we want to not do it at 60 seconds, Chair. Us, as a board, would like it to, everybody have 2 minutes, a little more. I guess, is that what this is saying, is the appeal to the board is that we could override the chair? It's also at a certain point, the chair's just got to make a call to govern, right? Like, we don't need to always have 15 different appeals on how much time somebody has to speak, maybe. I think that the way it's written in the Exhibit 1 is a little bit more clean and allows the chair to operate within that kind of leadership role when it is packed, when we need to make a decision, when somebody's at the dais and says, I remember this, 2 women. Well, she doesn't really like to speak, so she's going to stand here. Can I have her minutes too to talk about her? Chair Smith correctly said, no, we're doing this consistently all the way through the process for everybody. There is no augmentation. We've got to get through this evening. Maybe that wasn't popular, but they could have, at that moment, would they have appealed to us to on the fly change her decision? I wouldn't have supported that. It's her call to do that. So I don't know. I'm a little, that language there changes at the, it doesn't say that in the original. The chair will designate the time limit for any public comment and communication. I am fine delegating, giving that authority to the chair. I don't think I have to be appealed at every little moment within a public meeting. So I don't mind the original in E. I don't mind the adjustments of C and D in the minority report.
Okay.
I don't know what your thoughts are. I have a doctor's calling. I take a call. I have a doctor calling.
Oh, go ahead. Commissioner Savas.
So I don't have a lot of heartburn over either which one of the two, but one other scenario, and unfortunately Commissioner West is out the door, one other scenario that comes up in which, let's say there's a special guest or a unique circumstance, and we might want to hear, let's just say it's public comment, it's not a packed room, we might want to hear more from that person. And usually the chair is pretty judicious in allowing more time if needed, but sometimes, you know, the chair may not be aware that maybe 1 or 2 of us might be interested in hearing more from this person because we might have perhaps invited them or we know that they have something of substance to bring. So I don't see that as necessarily a point of conflict, just having the ability to exercise that.
I've always allowed for that. I don't see how that needs to be a rule, Commissioner Savas. Like you say, just turn your light on and you can speak at any time and ask. I don't see that that's an issue, that I have not allowed a board member to question somebody that comes up before us. I mean, the minute you start making something so prescriptive is the issue. I think it comes to a scrutiny of, oh, you didn't follow the rules, so therefore you're a bad commissioner. I don't want these board rules to be used as a weapon, and I'm concerned that they will be used that way. Jane?
So for Section 1, I think this really comes down to parliamentary procedure. Someone has to run the meeting. Someone has to have the authority to do that. I do think Section 1 on Exhibit 1 really does that.
Gary, your light is on.
Thank you. Actually, I was going to echo what Jane just said. You've already designated you follow Robert's Rules of Order. That covers 90% of what's in this board rules, by the way. You could have that one item, we follow Robert's Rules of Order, which is the assembly, which is you, can overrule the actions of the chair at any time. That's in Robert's Rules of Order.
Except for in Section 13 of the Minority Report is Sturgis. Why would we change onto a new operational manual when I don't think anybody here even knows what Sturgis is or the manual to follow? I mean, most accepted government bodies follow Robert Rules of Order.
Yes. And then also with respect, commissioners, you've already spent 30 minutes and you're still on page 1. So there's no time limit here, but this is why respectfully you haven't got this over the finish line in 2 years. So can you give general guidance to staff of what you'd like to see changed so that we can move forward is my recommendation. Thank you, Commissioners.
Commissioner Savas.
So there, Gary, I think you just pointed out, whether you meant to or not, that are we going to follow Sturgis or are we going to follow Robert's rules? The board had agreed to follow Sturgis because it was simpler.
When?
Okay. It was, many versions of Robert's rules can be very onerous and it's not really clear and it should be attached on which version of Robert's Rules of Orders we're going to follow or Sturgis, right? So if it's Sturgis, then maybe or maybe not, that issue you just pointed to is covered under the board's ability to ask or have the opportunity to ask for more time. The other thing I want to say, Chair, so this conversation goes smoothly, this is not a personal thing. These rules should have been adopted many, many commissions ago, before you were even on the board, and in between your prior term. So should not be personal. This is something that should last the test of time from commission after commission. It's just a shame that they haven't been in place many years ago. Frankly, when I got on the board, there were no rules. So this is something that precedes your term as chair.
And I said in my opening statement, I support Exhibit 1. Now, you made the statement that we adopted Sturgis, not since my time as chair, and nor was I informed when I took chair that we were operating under Sturgis. As a matter of fact, I believe when I came on as chair, I tried to establish a regular, consistent order of business that every commissioner would be familiar with and therefore be comfortable with to allow the most latitude of going forward. We're discussing Sturgis versus Robert's rules.
okay.
We need to stick with Robert's rules because we're familiar with that and we've been using it, is my opinion on that. And I consistently said that I do support the version 1. I am not subverting this, but we have discussed this. I think we've discussed this every single year I've been chair about board rules. Like I say again, I have been amenable to any commissioner who wants to bring something forward. I allow for ample opportunity of time for commissioners to express. And the reason why I established a regular order of business is because so we can discuss, fully vet something on our issues on Tuesday, so we can give staff direction to bring it back for a policy session. For instance, we just can't go to a policy session and have staff come in and expect us to read their minds. We need a framework of which to establish a policy session. On Tuesday, that's an opportunity for commissioners to opine on a particular topic. I would like to see this. This commissioner would like to see this. What is the law around this? Can we change that? So I'm trying to be really as amenable as possible, but commissioners, if you adopt something that is so strict, that does not allow for freedom of expression for any of us, including the chair, we may find ourselves stifled at moving the county's agenda forward. Commissioner Savas.
Yeah, so I'll clarify. It's correct, the board did not adopt Sturgis, but the board agreed that when we make the change, that we would adopt Sturgis as part of that. That is the distinction. So clearly under the agenda for all our business meetings, it says we follow Robert's Rules of Orders. No one's contesting that. But it was suggested and agreed that that would be the change because it was simpler. I don't care which one, just as long as it's attached and we follow it. So I'm not advocating for one or another, but that's the distinction and clarification of how Sturgis came into the conversation.
Well, the point of clarification is, however, Sturgis still is in the minority report. So if you didn't care, Paul, why didn't you just strike that, insert Robert's Rules of Order, because it's mostly we're all familiar with. And by the way, the public is most familiar with Robert's Rules of Orders, if they are at all paying attention to parliamentary procedure.
So can we just get back down to each one? So can we just, I feel that, if we get some consensus, do we want to have 1D from Exhibit 1, or I'm going to call it D1. Do you want D1 or D2?
Okay, where are you at, Paul? Section 1?
I'm on Section 1 of both,
So-
right? So I'm calling Section 1, or Exhibit 1, Section 1D. I'm going to nickname that D1, and then Section 1 of the Minority Report, Exhibit 2, as D2. So we want D1 or D2, version D1 or D2.
I'm still confused on what you're saying, Commissioner Salas. I'm not trying to be difficult. Just a minute. Let me gather.
Maybe Jane, if you could run that conversation, it might help us all.
Oh, here we go.
So I think this comes down to parliamentary rules. If we are all agreeing to Robert's rules, I think subsection D, Exhibit 1, Section 1D on Exhibit 1 does conform with Robert's rules, and that's that all questions and remarks will be directed to the chair because the chair runs the meeting. And then the chair recognizes people to speak.
Okay. And then could you move on again, getting back to the beginning of all those ones you identified were
Yeah,
distinct?
sure. And then E, I think it goes to the same issue. The chair will designate a time limit for any public comment or communication. Exhibit 2 adds subject to an appeal to the board. Again, I did hear some consensus that since the chair runs the meeting, the chair decides the timing. And then on F, the change here is current, under Exhibit 1, the chair signs all documents approved and delegates signing authority to the county administrator with consent of the board. That is changed to delegate signing authority to the vice chair or the county administrator or somebody else.
Why? Why is that something that's been changed?
I don't know.
It just seems right now it's pretty direct. You just go, okay.
Okay.
That's how we've always done it. Just goes to, I think the vice chair usually signs, right?
Yeah, if the chair is absent and conducts the meeting, the vice chair or the authority goes to Gary.
Yeah.
And sometimes, I don't know, have I abdicated my signing authority to Gary? I think I did once in the
Once,
very
yeah.
beginning.
Just once, yeah.
Yeah, and so I think that works well. Well, what if something happens? So first of all, let's talk about signing authority for a moment. Commissioners may not know. We have gone to mostly electronic signatures. So once it's passed here today, if I'm chair, my electronic signature will appear on many documents, but not all, because legally, some documents require a wet signature, right, clerk?
That is correct, Madam Chair.
Just give us a couple examples of what requires a wet signature.
Property deeds primarily require a notarized signature.
Okay, and there's a few other things that the receiving entity requires that. If I am unable to do that, let's say, a lot of times, I don't get that deed back for 2 weeks after we pass it here on the dais. Antonio, come into my office, can you sign this? Well, what if I'm unavailable? I mean, I was unavailable when I was in the hospital when I had double bypass surgery. So I am not sure who the signing authority was. I assume it was Vice Chair West, or maybe it wasn't, or maybe it was Gary. So the system works in that regard because I think we have redundancy set up in it already.
So we like F.
I think we like it in Exhibit 1 the way it is.
Well, in Exhibit F, it just basically specifies exactly what you said. In 2. Because it says if
we
you're
could
not
add Vice Chair,
available.
Vice Chair. Well, isn't that assumed, Jane, that if the chair isn't here, the vice chair, because that's mentioned later on in the document, in the absence of the chair, the vice chair will conduct the meetings.
Yeah, it says, up in B, it says the vice chair presides when the chair is absent. Part of presiding is signing documents that are approved during the session. So that would, I believe, fall to the vice chair. And so I think if those two positions are out, then it goes to Gary with the consent. I think that's very clear. So to move this forward, do I see some consensus around Section 1, current language on Exhibit 1 for this board?
The only change I might make, it's on is, it wouldn't be bad to have it more explicit in F, 1F, just to mention the vice chair.
Okay.
You just have it in 2 places, and then we know that's a fact. That's
What
the
was
only
that
thing we
again,
do.
Martha? I beg your
So what I would do here is, I would add the vice chair, delegate signing authority to the vice chair.
Okay.
Or the county, whatever.
Well, it says county administrator already.
Yeah,
Sure.
so I would just add the vice chair. It's only reason just to kind of
Yeah,
keep it
well,
consistent.
which is what you find in Exhibit 2.
Right.
Section 1F, that does mention the vice chair.
So,
So I think you like the wording in Exhibit 2, Section 1, subparagraph F.
Okay,
or I could say the chair, or if presiding, the vice chair will sign all documents approved.
yeah,
No, I don't care.
Okay.
okay, that's fine.
So if we have consensus on section 1, it looks like there is already past consensus or consensus between the two documents on section 2, appointment of vice chair and assignments, and section 3, minutes. So going to, nope. Yeah, going to section 4, meetings. The next change for this board to consider is on Exhibit 1, when it is in the public interest, the chair by majority of vote may adjourn a meeting to another time. And Exhibit 2 reads, the chair may order a recess of any meeting at any time for any reason.
I'm sorry, I lost you. Where are you again, Jane?
I am on page 2 of both documents under section 4, meetings, subsection 5.
Oh, okay.
In my opinion, again, is that this is, on Exhibit 1, subsection 5, the current language does align with parliamentary procedure and the chair running the meeting.
I'm fine with that.
I'm fine with the way it is in section 4, the one.
Where are you at, Martha?
I'm at 4, 5, when it is in the public interest, the chair by majority vote at any meeting may adjourn to it's just more direct.
I'm
Language in that one.
okay with-
I'm on page 2 of 6, 4, 5. On both of them, yeah. I think the major change here is accessible to the public. Right, well, no, they both has accessible to the public in it.
Not a lot there.
Yeah,
So do we have consensus there?
And which version are you looking at, Martha?
I'm looking at Exhibit 1,
And
Section 4,
sub 5,
Sub 5, yep.
that's okay.
I-
You like that?
I like the one, the original, or not the original, but,
The new one?
no, I like the original.
Exhibit 1 or Exhibit 2?
I like Exhibit 1.
Okay.
It just seems very straightforward to me. That's just me.
I think the intent was to give the chair more flexibility with Exhibit 2.
Okay,
And exhibit,
okay.
no, wait a minute, see, Exhibit 5.
Or recess of
I
any
like
meeting.
Exhibit 2.
Oh, okay, well, I can go with Exhibit 2. That's not going to break my heart one way or the
Well,
other.
it says I need the board by a majority vote to change the time or meeting or change the location. That would take away the ability, when we're setting these agendas, to say, oh, I would have to come back to the board before I could set, for instance, an NCPRD meeting when we were meeting at the pool and then we had to change to another location. That would inhibit my ability to be flexible when people come to me on outside. So I like the language in Exhibit 1, the original language, on 5, because, Gary, how many times have we been in a strategy meeting where, we have to change the location of, for instance, an NCPRD is just one of them, and we have to change it at a new time. Well, I wouldn't be able to set the agenda, and that until I had to have a public meeting of commissioners whenever we meet again, probably on a Tuesday, so we would be delaying and setting the meeting schedule. Does that make sense, Gary?
Happen?
Yes, it makes sense, and respectfully, document 1, it says it clearer than document 2. They say exactly the same thing. Version 1 says it better,
I'm fine with 1.
much more clear.
Well, my point was, the first words of document 1 say, when it is in the public interest. So my point about giving the chair or the board more flexibility and
Okay.
version 2 of 5 says the chair may order recess at any time for any reason versus the public interest. And now, I'm not anti-public interest, just make that perfectly clear, but you've got a limit on when you can actually change that. I guess you have to define or say, is this in the public interest?
Well, you want to strike out the words "in public interest."
I'm actually okay with just how it's crafted in version 2. I think you accomplish the same thing.
But it also says when it is in the public interest. So both versions say it's in the public interest. So you can't say you don't want the one on Exhibit 1 because of public interest, that you don't like that, and then adopt it on the minority version in number 5 when it does say in the public interest.
Well,
It's
actually,
inconsistent.
actually, if you read the first sentence, it's clear, it gives that authority, first sentence, carte blanche, okay? The second sentence has a different purpose, in that if it is in the public interest, then the board has a majority vote.
And so who's going to challenge public interest, and who's going to define when it is or is not in public interest? Jane?
I think this goes back to the chair running the meeting. I do think that if you go with version 2, you're going to have much more internal debates and contentions around certain things that may come up at meetings. And I just think it's more streamlined and frankly, more aligned with parliamentary procedure to go with the language as written in Exhibit 1.
And I tend to agree with that, Commissioners. I mean, Commissioners, it's how much time do you want to spend on procedure in our meetings, or do you want to get the work done? I think you look at our workload that we currently have. We have a lot to do.
I can go with version 1, so if I could just express that, and we could just move on so we can get this done. I just want to get it done.
Okay, so I just want to backtrack. So we have consensus around Section 1, Section 2, Section 3. Do we now have concession around Section 4, subsection 5 consensus? Okay, so moving on to 4, B, that is the same. Executive sessions is the same. Let me look here, I have D. Okay, so the next change comes up in Section 5 under notice and agenda. So Section 5D, under Exhibit 1, the chair sets the board meeting agendas. 2 other commissioners may place matters on issue for discussion. The proposed language in Exhibit 2 is the chair will establish the agenda for each meeting of the Board of County Commissioners. 2 or more commissioners may call a meeting or place any item on the agenda of a meeting on the Board of County Commissioners either directly or over the objection of the chair.
So if I may, Chair?
Jane, did you have a comment on that?
So I will say that this language, just looking at it, gives me a little bit of concern around the voter, the chair position here in Clackamas County. 2 or more commissioners may call a meeting. That does seem to contradict the chair position role here, where I think it's pretty clearly delegated that the chair calls a meeting. The chair sets the agenda for a meeting.
Based on what voters said when they went to a 5-commission member,
I'm
correct?
going to say based what's in our code.
In county
Yeah,
code.
in our code, yeah.
Paul, go ahead.
So actually, this is the one that's probably the most relevant for me here today, and that is, could you read the county code as it applies to that?
Yes.
Because that's what the voters did vote on.
So County Code 2.11070. The chair shall establish the agenda for each meeting of the Board of County Commissioners. 2 or more commissioners may place any item on the agenda of a meeting of the Board of County Commissioners over the objection of the chair.
Can we just insert that, because that's code? I'd be happy just to insert that. That's code, that's clear. That is the issue, that why we're here today, frankly, is that there have been a number of items that have not been placed on the agenda when 2 or more commissioners have exercised that ordinance.
If it's the code, I'm fine with placing it in the rules.
Yeah.
It is, I mean, it is what it is. We already have to follow it.
Well, it says on version 1, 2 other commissioners may place matters on issues for discussion. Now, that's different than, is that different, or is that not different than, quote, an agenda?
Well, so the way that the county process works is generally before something comes to like a hearing or, and Gary can probably speak to this better than I, it comes to issues, the issues meeting first. And Do we want to have a policy session on it? Do we want this to have a hearing? Do we want to direct staff to work something up? So the first meeting that this comes to is issues, is my understanding.
Correct. So here, the issue is this, commissioners. Yes, 2 commissioners can place an item on the agenda, but do you get to schedule it? Because everything you've asked for has always been put on the green sheet, but it's not been scheduled at the time some of you may want. The chair sets the agenda, which I interpret as the schedule. So I guess that's a confusion to me. Is it scheduled or putting it on the agenda? There's a difference. I don't want an hour discussion here, but that's really the issue. I think following the code is pretty clear.
I think following the code is clear.
Okay.
Oh, Savas, is your light on again?
Yes, it is. And so the other issue, maybe we need to add another letter, another section. Let's talk about issues. So that's different. So the current practice is 1 commissioner can bring an item on issues on Tuesdays. So this says 2 different things, so I want to, that's why it needs to be fixed.
Well-
So it's the county ordinance, if we are all clear, that just inserting that exact language and add another letter that says a commissioner can bring something under county or under issues for a Tuesday session. That's current practice.
That's current practice. I mean, why would we want to prohibit what's current practice?
Yeah, we just put it in black and white. It's
Yeah,
fine.
put
I'm
it in
fine with
black
that.
and white.
Okay, so I want to make sure I understand. You want to keep D as written on Exhibit 1, but you want to add another section under Section 5 that recites the county code language.
Perfect.
Okay, all right.
Well, but under number 1, it says 2 commissioners. The current practice is 1 commissioner.
On issues for discussion,
On
you're
issues.
talking agenda. So,
Agenda and issues are 2 different.
so what the current practice is very liberal. 1 commissioner versus 2 commissioners. The current practice is 1 commissioner bring an item. If we adopt this code here, only two commissioners have to agree. I'm saying 1 commissioner can bring whatever they want. I've always said that,
On issues.
on issues.
But agenda takes 2.
What's an agenda? That's the issue.
That is the issue. So do we want to, so we have two separate things. Issues, which is Tuesday, typically, and then there's the agenda. So if we want to use 5D to address the issues question, then maybe we just strike the chair sets the meeting agendas, strike that. We're not contesting that. And just says a commissioner may place a matter on issues for discussion. That's just addressing the issues question.
I think there would be a concern in my mind if you struck the chair sets the board meeting agendas, because if this becomes a living document, people are going to refer to it, new commissioners, this institutional knowledge will be lost. So I think if we're going to have a document, it should be very clear. So that should be, that sentence, the chair sets the board meeting agenda, should be included.
Okay, as long as we got the county, or Jane, what's your recommendation to address the county ordinance for 2 commissioners placing on something on the agenda, and also the other question of the issues? And the chair's been great about that. I'm not contesting. There's been never any resistance to placing an item on issues, so.
We have 2 lights on, Commissioner Scholl and then Gary.
Okay, so on this, Section 5, subparagraph D, we've never had any problems with a commissioner putting something on a Tuesday morning issues meeting. The process is, by Thursday at 5 o'clock, the commissioner goes to the county administrator and says, I would like this on the Tuesday morning issues meeting. I want to talk about cats and dogs.
Because that's how you.
Okay,
enforce
then
it.
that goes on the agenda, on the schedule for the public to see that Commissioner X is going to talk about cats and dogs on Tuesday morning at issues. That's not a problem. Where the verbiage came in on Exhibit 2, Section 5D that we're looking at here now, goes back to an issue where, as I recall, Commissioner Savas wanted something on the agenda, not at issues, but something on the agenda like a policy session, or
Like board rules.
a topic, whatever it might be. And then he got another commissioner to agree that, yeah, we need to have that on the agenda for a policy session. And so that's the issue here. But the other thing too is, just like on Section 5, well, Section 5D on both documents, what's the process for that? For example, if you and I wanted to have something on a policy session on cats and dogs, and do I go to the chair and say, I would like to see this on the agenda for cats and dogs, and then you go to the chair and also, so we got two people saying we want discussion on cats and dogs on a policy session, right? Then the chair says to the county administrator, okay, let's go ahead and schedule a policy session on cats and dogs. Because that's always been a question. What is the process for the two commissioners to actually tell the chair that they want something added to the agenda, the schedule?
Gary, your light is on.
Thank you. I'll answer, if I may, Commissioner Shull. I request that's a public discussion. You say it publicly in front of each other. You'd like to schedule something for a policy session, the chair may say no, and then two of you say yes. That's when the administrator hears it. That's my suggestion. But why I raise my light, I suggest on document 1, 5D, you take out 5D entirely and put in exactly what's in the code, which is different from 5D, and then you can add a new section that Commissioner Savas said. Any commissioner can add an item to issues.
Yeah,
That's my recommendation.
they're
We're
two
talking
different
about two
things.
different
Yeah,
things.
that'll work.
I agree with what Gary just said.
Yeah, that'll work.
That's fine. Aren't we already doing that?
I think we got confused here, but that's
I
what,
think we got
Well, the
confused.
agenda's different than issues, okay?
Commissioners,
I
we
mean,
really need to move this
meeting
along.
agenda.
You know, we're going to be taking this up after lunch, and I will recess promptly because we have a commitment to the rest of the county employees to attend their appreciation lunch. I don't know who all is attending, but as chair, I hand out the certificates. Commissioner Savas.
Yeah, I agree with your language, Gary, and whatever the procedure is, what has not been clear is there's been, to Commissioner Shull's question, there's been two methods of employing the county ordinance. And one is do it at the dais, and sometimes that gets lost, right? That's not always remembered by staff. And the other one is two commissioners submit something to the administrator via email, so it's a public record. We both want this on the agenda, right? Or three commissioners want it on the agenda. So whatever that rule is, let's make sure we understand what it is.
Now, I kind of have an issue with emails because rarely, commissioners, do you notify me, the chair, that you want something on the agenda. You tend to subvert me and you go to Gary. So if something is sent to Gary by email, I may not get it and I may not be prepared to deal with that. So whatever you do, I think it needs to be consistent. And if you're going to send an email to Gary about an issue, you should send it to every single commissioner, including me. Because that's been an issue that I've had trouble with. Oh, Gary will say, well, this commissioner wants that. Oh, well, what's that about? So I'm sitting here trying to manage a situation or an issue or a policy that I'm not prepared to do.
Emails.
Gary? Oh, Paul or Mark?
Hey, Joe.
Joe, Bill, Harry?
So, okay, this is the way I would do that.
Okay.
I would say I got an issue on cats and dogs. Go to the administrator. He puts it on the schedule. I talk about it at issues.
Okay.
Prior to the issues meeting, I speak to another commissioner and say, look, on this issue, I believe it's going to take a policy session and we need to get it on the schedule. Would you be willing to be a second commissioner asking that this be put on the agenda?
Add issues.
And that way,
I like
everybody
that.
sees it, the public sees it, they know a little bit of background on why I'm going to talk about cats and dogs and why I need a policy session on it.
And that's basically my intent of doing this forward. That is what I would like to see.
Because the email can slip through the crack and somebody say, well, I didn't see that email, right?
Yeah.
Okay.
Oh, yeah, absolutely. In fact, I've had trouble with my laptop and my phone in recent weeks where I'm not getting emails when maybe people think I am.
It's the Russians doing it.
All right, thank you. Gary, your light is on.
I request that you make the public request to commissioners for an agenda item, not an email. We want to avoid any accusation of serial voting by email, you should all hear the request at the same time. So I requestfully
I agree with that.
ask, please, public, thank
We
you.
don't want to be serial voters.
So how do we codify that?
I think a verbal request at issues,
Well, I mean, in the board rules that,
a verbal request at issues. That's how I think we need to.
well, it could come up at a business meeting as well. I mean, I don't want to block our ability to do that at any meeting. I don't mind having the topic come up at issues as a mechanism, but if something comes up on a Thursday, and we feel it's ripe, I don't want to have to forego that it can come up on Tuesdays. That's not county ordinance, right?
Well, yeah, but we're going to have to discuss it on Tuesday because we work 4/10s. So we bring up something at 11:30, Paul, on a business meeting, and you know this. You've expressed great frustration in this. And we come forward, and the staff has not had ample opportunity, because they're not working Friday, Saturday, or Sunday, to give the board what we asked for because we have not made the request clear. I think a discussion is one thing, but moving to a full-blown policy session on the fly at a business meeting is extremely problematic and really not professional.
Well, no, sure, if I may.
Yeah, Mark?
Okay.
Mark's line is
Well,
on.
getting back to this again, I know we're beating this up pretty good. But the idea to do the process I mentioned before, to bring in the initial discussion up at an issues meeting, okay, with two commissioners advocating that go on the schedule. That issues meeting, there's initial discussion on it. At that discussion, what could happen, three other commissioners could say, hey, that's a bad idea. We're going to vote on this and not put it on the agenda, and it's a done deal, you see? So that's why I like the idea of this weekly cycle we have to bring it up at issues, to give it an initial look-see by the board, and then see where it goes from there.
Okay, yeah, that's what we've been doing, and I think it's been working well. Commissioner Savas?
Yeah, so, for the situations that, and I'll just use your analogy of critters here. If we're discussing on Wednesday cats and dogs, and we want to talk about bunnies, right? We could say, by the way, can we, I would like to have that on the agenda to include bunnies in the conversation, right? As just using your example of critters. Why would we, again, bring it up on Tuesday if we already have decided? It's not to say that we want it on the agenda tomorrow or next week or the week after, clearly. No one's saying that it has to be immediate or at the next business meeting or the next work session. All we're saying is that we want it included. It seems be a waste of time to bring it up twice.
But maybe not, because when we discuss items on Tuesday's issues, I tend to look at that as fleshing out the issue to make sure that we do want to pursue it, that we all can voice our pros and cons. Gee, do we want to go down this? Do we want to, eliminate this? Do we want to add this? I think we should have maximum flexibility in discussion of the issues of this board. And I don't want to see anything in the rules, Jane, that keeps us from doing that.
Yeah, at the same time, the county ordinance does not say you can only do it on Tuesdays. County ordinance says.
No, but that's when we have time, because, Paul, as you know, on Wednesdays are our land use hearings, our other hearings, and policy sessions that have already been set. So if Wednesdays are not a good time, because usually our schedules are full with what we already decided on issues previously. So that's I've tried to be really clear on the designation of days that we do our business. So really, the public knows, well, on Thursdays, we have our business meeting. On Tuesdays, we do this. On Wednesdays is land use and policy sessions, like today. Today's a policy session. And I think that's working well. Commissioner Scholl?
Okay, so if you remember back to 2021, early 2022, the year in there of the emergencies, ice storms, windstorms, COVID, fires, Martians from outer space coming down. What we had then was, what happened was we did have emergency meetings recommended by some of the commissioners, we need to meet, emergency meeting to meet on this issue. Then, and those were scheduled, as I recall, sometimes in the same day, announced in the morning at 8 o'clock, and by 3 o'clock, 4 o'clock, we were all back in here to meet on a hot item. So we've done that. Yeah, but the idea of using the issues to start a topic gets us in this weekly cycle that I think is very effective.
And like you say, Commissioner, we need to be flexible. I shouldn't have to declare a countywide emergency to have an emergency meeting of the Board of Commissioners, and you're right.
So what I'm hearing, if I may, is consensus around adding the code language that I read to you as a new section, and then with respect to Section 5D in Exhibit 1, deleting the chair sets the board meeting agendas because it's in the code. I think that was Gary's suggestion. My question for the board is 2 other commissioners may place matters on issues for discussion. Did I hear 1?
That's the policy.
Okay. And is everyone okay if I change that? Is there
To
consensus?
1.
To 1.
Yes.
Okay.
And that's what it is now.
Okay, all right. And then can we move on to section F? There's absolutely no change here, really. The difference is in the second sentence. There's any commissioner on Exhibit 1 and a single commissioner on Exhibit 2. So to me,
Okay?
okay. And then G, I think the significant difference here is on Exhibit 1, agenda items are taken out of order at the discretion of the chair or the recommendation of the county administrator. Exhibit 2 says, taken out of order at the discretion of the chair, but adds any 2 commissioners or the recommendation of the county administrator.
Gary, your comment?
I don't recommend Exhibit B because you could argue, I could see a scenario with a future board will argue for 40 minutes whether 2 commissioners want to change the agenda or not. I think that's the role of the chair, or again, the assembly can overrule the action of the chair at any time. So I don't
We're
think
talking G?
G. I think Exhibit 1 is appropriate.
I would agree, because commissioners, we're going to get so bogged down in procedure that we're not going to get anything done. Just show up and do the business as fast and orderly as we can. That's where I'm at. Consensus?
I'm okay with it, leaving it.
I'm okay with that.
I'm okay with it. I don't
You're
have a
okay
problem
with
with it, yeah.
Okay, go ahead, Jane.
Okay, so for section 6, there's an addition in Exhibit 1 that, section B, that does not exist in Exhibit 2. And that is that if you have an anticipated absence, not an emergency absence, not a sudden absence, but an anticipated absence, that you're going to provide verbal, written, or an email notification to the chair or the county administrator, each other and the county administrator. I mean, that.
Okay, listen. So I'm setting the agenda, and Commissioner X wants to have a policy session come up. I set the policy session, and then I find out later they're on an extended vacation, because I don't even see that until it comes up on my schedule on the cell phone. That's a problem for me. That has happened, I can't tell you, more times in the last 2 years than ever before. So I would like to know when a commissioner is going to be gone in order to schedule the meetings. For instance, I may schedule the rehabilitation center approval on the agenda. You have taken a vacation, but I don't know you're there. I would not want to go ahead with that when you're on vacation. This is why this is important, and it's a lack of communication really upon the commissioners to let others know, or let the chair know so I can accurately set the agenda. Now, you may tell your policy advisor. Policy advisors don't tell the chair when commissioners are going to be gone. It just doesn't happen. So I would like to be able to say, hey, for agenda setting, that's the only reason for agenda setting. You can feel free to leave and do whatever you want, but I don't particularly want to be able to skip. And you've heard me say, commissioners. Gee, we need all 5 commissioners to consider policy X, so I will hold something over. I should be able to have the flexibility to do that when I know a commissioner's going to be gone, and I know that they have a personal interest in it. This is what is problematic for me in trying to run all the agendas for what all the commissioners want. Paul, or Ben, you're up first, I'm sorry.
The only issue I have is the public doesn't need to know if I have a private doctor's appointment.
No,
Right.
I agree, but I need to know, not publicly, I need to know just to set the agenda.
I just don't think it has to be by email, by public record. I think there are things that are in private life that can come up with family or personally where we can figure out how to better communicate. I hear you on that, but I just
We
don't,
have
I don't
to
want
do
it on
by-
public record if it's
We don't have
personal.
to do it on email, we don't have to do it on text, just call, I don't know, if you can't get a hold of me, call the policy advisor, so I can know. I just need to know, Jane.
The other thing is, I don't read this as requiring any explanation why you're going to be gone. So I don't think you have to say, I don't think you have to tell people why you're gone. You just have to say, I'm going to be out next Tuesday.
But the point I'm making, Jane, is I need to know that.
Right, but not the why, I'm
No,
assuming.
I don't care,
Yeah,
whatever
that's what I'm
why.
saying. Yeah.
I'm assuming that everything is copacetic and we're not ill.
Right.
Okay, if I ask a question, it would be out of concern for my commissioner, okay, for the commissioners, okay. But I need to know, and the problem is the communication is not being relayed to me, or my policy advisor, so I can assist on setting the agenda. So how would you?
I would keep it as it is. I was just pointing out that this requirement does not require anybody to explain why they're going to be gone.
Okay, but it says electronic mail notification. Commissioners, do you want to leave the electronic mail notification in this?
It's an option, yeah.
It's an option.
It's an order.
Gary?
What about take out the words verbal, written, or electronic mail, so it just says, commissioners will provide notification? And you can all figure out what that means, how to communicate that.
Commissioner Savas?
Yeah, I think it's fine the way it is, frankly, and it makes perfect sense to have that in there, and I want to make sure everyone realize this says anticipated absences. Now, there's the unanticipated absences, and maybe there's an emergency, you're not going to call all 3 people.
No.
Or maybe you can't use email, and all I can do is get a hold of Gary, or I can only get a hold of the chair. So the system works for the most part, and just so anyone watching this, I do understand the difficulty when we have absences, right? That's where it gets difficult. But just so the public knows, and we all know, that there's the weekly strategy meeting in which you all have our schedules, and when the agenda is being set with the chair, you already know through our policy advisors, through everything, who's going to be where, when, for the anticipated absences. We already know that, it's in practice. I don't see a big challenge with that. It's the unanticipated absences that can be a problem for all of us, including the chair.
Or last minute, because as you know, the agenda from the green sheet is set a couple months ahead of time. And then agenda could be set, and then a commissioner could decide on an absence, on an anticipated absence. Fine, I just need to know that as soon as possible, so I can go back and make a change in the agenda that we thought we were going to have.
Right.
So this allows for that flexibility?
Absolutely.
All right.
Yes. And then everything else is the same as Section 6. And then Section 7, voting, the 2 versions are identical in that language. I want to make sure that's true. Yes. And then Section 8, public testimony, they look the same to me. Section 9, ordinances, they look the same to me. Application of rules, same. Where we get to our next change is Section 11, board messaging,
Just a moment, Jane.
and that's on page 6.
On page 6.
6 of Exhibit 1 and page 5 of Exhibit 2. Under Section 11, 11A, board messaging, Exhibit 1 says after a quorum of the board has reached a final decision on any matter before the board, each commissioner shall support and respect the decision of the board. That sentence is identical in Exhibit 2, but Exhibit 1 has an additional sentence after that that says, any commissioner may express their position or basis for opposing a position taken by a quorum of the commission, but should not actively attempt to undermine a decision of the board. That sentence is not present in Exhibit 2.
I think that, to think that we're all going to agree 100% on every single item is not appropriate. I do think that we should be able to have the freedom to express, gee, the board voted this, I disagreed with this, and if you can explain it or not. I don't want to try to see, I don't know what you mean by undermine a decision. I'm not sure where that language came from or exactly what it means. Commissioner Scholl.
Yeah, okay, so the language in Exhibit 1, I think, should stay there. And, okay, so we all have agreed through our Clackamas spirit, this,
Yes.
that after a 3-2 vote, even if we voted no, we do not work to further object or to try to change that 3-2 vote, even if you voted no on it. But what happens is, in the public, Commissioner will often be asked, Commissioner X, why did you vote no on this? And then it's your obligation to explain your reasoning for voting no on it. But like here just this last week on the RVs, for example, where we had a 3-2 vote to approve the RVs, I do not take any action to try to subvert or change the 3-2 vote, even though I was a no on it. But people will be asked, could you please explain your reasoning for voting no, which you have an obligation to do. But I tell them, this is not an effort to subvert or change the vote that's already been decided by the board. Because if we do that, we'll be here forever in 1,000 days and never get anything done, always wanting to go back to change a vote.
I understand commissioners are going to have a different opinion on the way the vote went. To me, we should have the freedom and the expression as an elected official to say that. What I question in the here, Commissioner Scholl, is undermine a decision. I don't know what that means. How on earth do you define that, and is it subjective?
I don't know if it's quantifiable or not.
It's not
actually.
quantifiable. I would, I might want to strike that, because I think, look, I think if I have, for instance, an objection to Martha saying something, I should have the wherewithal as an elected official and the respect to go to her and say, Martha, I disagreed with what you said on that. I don't think it needs to come back to the board for a judgment call. I just don't want to see us do that. Ben?
We operate as a body. We're not legislators, and we're nonpartisan. And when the board makes a decision to move forward in that, it is us, even if it didn't go our way, doing it together. I can think of instances where there has been some passive-aggressive behavior where some commissioners, in my opinion, have undermined the effort that has been the majority decision of this board, in my opinion. And I would not have taken that same action even if I had the no vote. I don't need to call out any names, that's not productive. But once a votes happen and then you're doing some things behind the scenes that are subversive or lobbying against the decision of the board, then you're undermining that decision. So that word is important to me. If the board's made a clear path of moving forward in a certain direction and you're trying to alter, subvert, or change that or rally up public opinion against it, you are undermining the decision of the board. If you're sharing information that isn't completely accurate to the public and it gets them riled up, you are undermining the position of the board. It doesn't always go our way, but we do operate as a body, as a differently than an individual partisan elected. So I think that there has been examples, not overly over, where there has been undermining of board decisions.
So you would define undermining as lobbying, alter, subvert the vote of the board. Jane, is that necessary?
That's a decision of this board. That is not a legal question. That is a policy question.
But are we going to, sorry.
It's okay.
are we going to be having difficulty in defining, for instance, what lobby means? See, it all goes to the definitions and how we operate.
Right.
I think it's the point. I think it's the point of, that, if there is, maybe we try to deal with it, but it should be discouraged. And that's why I like the language, to keep the language there. I think it's really important. I can name examples. No one here on this board, this example that I'm using, where that has happened. Matter of fact, even went so far as that particular commissioner influencing staff to help them undermine it. Okay? And I will say that the former administrator, once he learned of that, addressed both the staff and the commissioner for doing that. No one here, but it has happened. I like the rule. I'm happy with the language.
I'm just concerned that, you undermined me, and I don't want that to be construed, Paul, as a commissioner explaining their position or disagreement with the majority of the board.
Giving a clarifying statement for your vote is one thing. You have the freedom of speech to do that, especially as an elected, to say, I voted this way, here's my reasoning. Then you begin to take action beyond a clarifying statement, then you are now undermining the will of the board in a specific direction.
Okay. Commissioners, I'm going to have to adjourn this. I need to go back to my office. I need to get prepared for the meeting downstairs. It starts promptly at noon. Gary, I recommend that we continue this
And we'll get through it.
after lunch, and when we come back at 1:30.
So, Chair, can we just close this one item? I mean, is there a consensus to keep it?
I think there's consensus to keep it.
Okay, so let's,
And then let us come back.
nail that one down.
Consensus that we won't revisit anything between 1 and section 11?
Yes, we
Okay.
can, we start, yes.
Okay,
Okay.
all right.
Commissioners, we will recess and reconvene at 1:30.
Right.
Thank you very much.